SJC-12622, Boston Globe Media Partners, LLC v. Department of Public Health.
Good morning, Mr. Albano. Before we start, I will note that Justice Slank is not physically here, but she is at home. She is watching the proceeding. In contrast to the United States Supreme Court, one is able to do that in this court, and she will be assembling with us by telephone. So she is participating in the proceedings. So I say good morning to you and to Mr. Porter as well as to Justice Slank. So with that, you may proceed.
Thank you, Your Honor. With the court's permission, I hope to address three issues in the time that I have here today. The first one being that the court has not changed and should not change the threshold test under Exemption C that triggers whether the balancing process between the competing interests needs to be made. That's point number one, that threshold test, whether the information concerns intimate details of a highly personal nature, has been since 1978 the requirement for proceeding with an Exemption C analysis. The second point I hope to address is that if the court deems that threshold test was met here, or even modifies the threshold test, that the appropriate result in this case would be a remand for further fact-finding on whether an unwarranted invasion of privacy would occur upon the disclosure of the requested records. And the third point I hope to address is that if there is such a remand, I would suggest this is, as the court has done in the past, the type of case where it is appropriate to suggest to the legislature that some 40 years after the adoption of the privacy exemption, Exemption C, it is appropriate for the legislature to more properly, to better perhaps balance the competing interests in between, one, the benefits of digital journalism in the modern age, and two, the concerns that the DPH has expressed. As to the first point, it does seem to me that a writing that former Attorney General Edward Levy once made is appropriate guide to the Exemption C statutory question, because he wrote that in matters of statutory interpretation, the court actually has less leeway than in common law or even in constitutional cases. And so he wrote, because the test there is, what did the legislature mean? And its meaning is then fixed. Once the meaning is fixed, subsequent cases must be decided upon the basis that the prior meaning remains. It must not be reworked. It is, he said, a hard doctrine against which judges frequently rebel. The threshold test for Exemption C is the information at issue. Intimate details of a highly personal nature was first adopted 1 year after the Exemption C was amended to include the unwarranted invasion of personal privacy language in the Hastings and Sons case.
Now, I'm sorry.
Yes.
Mr. Albano, as far as that threshold, and then if we get to that, to the next inquiry of invasion of privacy, could you address this whole notion of vertical versus horizontal? Because I think what the government points out is the amalgamation of this data is really the bugaboo, not a particular issue. And could you please address that?
Yes, Your Honor. The response there is simply this, that the compilation concerns that the courts have expressed the Supreme Court in the Reporters Committee case, this court in New Bedford Standard Times addressing the Corey statute has consistently been, does the compilation drill down on an individual's personal history? Do you get the rap sheet that contains 20 years of interactions with the criminal law system? Do you get the Corey record that goes through? These cases do not concern shallow, as the amicus have described it, shallow data sets that go across, that tell you just a little about a lot of people. Some of us remember the phone book days where you could have compilations of name, address, and telephone number of hundreds of thousands of people. That's a compilation. It's a lot of information, but it is not an invasion of privacy. And so we say here, because the birth date information and the marriage information is in its component parts public, no question about that, that if you get a lot of them, it's more like the old fat phone books than it is like a criminal history
Except a
record.
large group of data like birth dates and maiden names or pre-married names would end up in a large package being something very valuable for sale on another kind of market.
There is certainly the opportunity for, and the public records law acknowledges this, that commercial players can use public records. That has happened before. That was at issue in the Doe case. There's several out-of-state cases cited by the DPH in support of its position. I would say that the best case, certainly the best case from my perspective, is Judge Gershengorn's opinion in Doe 2, where after a trial which concerned access to the records at issue there, over 4 million registry records that included birth dates. After trial, Judge Gershengorn said, birth dates and height are not intimate details of a highly personal nature, even though in that case there were other uses that would be put. There is an older SJC case, the registry case, Registry Daily, something, it's in the briefs, where it was in the 1930s and a company was literally putting their people, actually, I recently reread the case, they said they brought their girls in to copy the registry information for a commercial purpose, permissible. Here, of course, it's not being used in this requester, by this requester, for a commercial purpose.
Putting aside any mining concerns, what about identity theft issues, fraud issues? Is that something that we should consider?
It's a fair consideration here, Your Honor. I would suggest there's two responses. First, it is very significant that the legislature, the same legislature, not the same people, but the very legislature that adopted and enacted Exemption C, had, when it passed what is considered one of the best data privacy laws in the United States, Chapter 93H, excluded birth dates from sensitive personal data, as did the court in Rule 124, I think it is, protecting personal data in public court filings. Social security numbers, protected. Credit information, protected. Not birth dates, and that, I would suggest, is significant. I would say that if we get by the threshold test and we're actually balancing the public interest against these potential concerns, that, I would suggest, underscores the need for further fact-finding here. This case will have a significant impact on future cases involving access to digital records. We are today, in 2018, talking about the appeals court decision in 1988, the first Doe case. And what does it mean about access to compilations? That will surely happen again, and the record in this case has no evidence about how, given, for example, Chapter 93H, given how identity fraud really works, how likely is it, if at all, that the disclosure of this birth date information would constitute an unwarranted invasion of personal privacy?
Let me pursue that. Do you agree that if this did materially increase the risk of identity theft, that would fit within the rubric of being an intimate detail of a highly personal nature?
Well, I have to say no, and may I explain why? I say no based on the court's decision in PETA that leaves me uncertain as to whether these kinds of concerns are properly encompassed within Exemption C. I mean, for example, the reasoning in PETA when the court expressed doubts about whether personal safety fell within Exemption C and noted that its cases had previously allowed the disclosure of home addresses and names, and that the legislature had amended the public records law to add an exemption for that information, indicating that it was not within an Exemption C privacy because it's not an intimate detail of a highly personal nature, but more of a security concern. So outside Exemption C, but properly the subject of legislative action for sure. But here again, we do know something about what the legislature thinks here because of Chapter 93H and its exclusion of birthdays.
Let me, if indeed it were determined that this did materially increase the risk of identity theft, would that be something which would at least trigger a balancing test?
Not under Exemption C, Your Honor, because it would not be an intimate detail of a highly personal nature. If the court, I'm not trying to be a stick in the mud here, if the court said that, yes, that the test is not as it has been before, that we will consider factors other than, is the information intimate details of a highly personal nature, and one moved on to the balancing test,
So is
then yes.
Is one of your, the reason why you say it needs to be remanded is basically the trial judge's assumption that this was going to lead to identity theft?
Yes, there was a lot of, there was citation to some articles, to cases from other jurisdictions. The DPH says you may take judicial notice of what those cases say. I would say two things to that. First, if we're going to take judicial notice of a case, I would say let's use Judge Gershengorn's decision here in the Commonwealth that says birth dates are not intimate details of a highly personal nature. Secondly, though, those other states, those decisions are really of limited utility because I certainly can't tell from reading those cases whether in those states, as in Massachusetts, the information is freely available. There are states where you need to be either the person whose record is being requested or the parent or child in order to get a birth date. So those other state decisions, I think, are of limited utility. And so directly answer your question, Your Honor, yes, I think there needs to be, if this is the path we go down, and Chief Justice Gantz, maybe to more directly address your question, if, as PETA suggests may be the case, the privacy exemption does encompass, in limited circumstances, personal security concerns, then the answer to your question is yes, there would be a balancing. And the answer to Justice Gaziano's question is, and that balancing would require a more fully developed factual record and some actual evidence of the risk of identity fraud than exists in this case.
So let me just be clear. You said it would not be a exemption C, but PETA, the security concern, a physical security concern for the safety of those individuals was done within exemption C.
And the reason I phrase it the way I do, Your Honor, is when I read PETA, and this is just my reading of it, it seems to me the court was struggling with, is this really an exemption C issue or not? We haven't decided it. Maybe it is. If so, it's a very heavy burden that the agency would carry. And I read it as not quite coming out and saying, yes, it is, but rather saying, as I suggest should happen here, there needs to be a more fully developed record before such a conclusion could be made under exemption C.
Which in PETA we did. We asked for a remand.
Yes.
Okay, one other concern. I know your time is up, but if a child in 2018 is adopted, the birth certificate, I gather, is changed to reflect not the birth parents, but the adopted parents. If a child born in 2018 has a birth certificate which claims that the husband is the father, and it's later determined that paternity was somebody else, the birth certificate is changed to reflect the true father. If a child born in 2018 decides to change his or her gender, the birth certificate is changed to reflect the change in name and the change in gender. And all of that is protected from disclosure, correct?
Yes, Your Honor.
So if you get data from 2018, you will get all the information that occurs before any of these events have happened.
I think what the stipulation of fact shows is that if the request were honored, we'd get a snapshot as it existed at that moment in time, which would be pure of any.
Okay, so you would get it, so let's assume you would get it tomorrow.
Right.
You get it, and so your point would be that you would not know about any change.
Correct.
Okay, so let's assume you prevail and you get it tomorrow. And then, because it's allowable, you or somebody else comes back in 2020 and asks for it again, in 2021 and asks for it again, in 2022 and asks for it again, and you would then be able to cross-check and identify individuals whose names had been changed because they've gone transgender or because of a change in paternity or because of an adopted. So I understand that you're not asking for that now, but if we say you can get it, then you can come back every year and say, give us the annual compilation, and then you can do that, and you can identify individuals whose information is statutorily protected. How do you get around that?
Here's how. As the Superior Court expressly found, it would be an entirely different public records request raising entirely different and meritorious invasion of privacy claims for one to make the repeat request a year later. The Superior Court expressly stated that in her opinion. We conceded it below, that all that would be accomplished in this case, I don't say it all to minimize it, but because it would be significant, but we get the snapshot today. Unless the legislature makes changes, modifies how this can be done, the fact of the matter is a later request by any requester for anything other than what was released in digital form pursuant to this request would raise starkly different privacy
So let me
issues.
understand you. So you're saying you asked for it and you get it as of February 1, 2019. The Globe comes back February 1st, 2020 and asks for it, and they're supposed to say, no, you got it in 2019, you can't get it again.
Yes, unless the Globe or any requester can address the issue that you've raised, Your Honor, and that was raised below, which is if you get multiple years, it is possible to make.
Right, so let's assume the
comparison.
Boston Herald comes to us in 2020 and asks for it. Is anybody supposed to enforce something which says Boston Herald? I guess we know the Boston Herald doesn't talk to the Boston Globe, but let's assume it would be somebody who would talk to the Boston Globe. How is that going to become enforceable? Since that the Boston Herald can't come back in 2020 because the Boston Globe did in 2019.
I do think there's a workable solution here. There is a data set that would be publicly available today. That data set would be publicly available, today's data set would be publicly available a year from now to the Herald. The DPH, the Attorney General's office, and anyone who read the Superior Court decision and whatever this court writes would see plainly that there is quite a different privacy analysis if you are getting comparative databases that allow for the discovery of gender reassignment surgery or adoption. It's a different request, raises very different privacy issues that are not raised by this request, which would not enable anyone to make those comparisons.
The consequence then would be that you get it, but that the next requester would not.
No, I
Or
think
the next
not. I
requester
think-
would get the same data you got.
Exactly.
So
This-
So then once the
in
request is
2023,
made, nobody else can get the data.
That they get the very data that would be disclosed to the Globe in response to this request. There's nothing we
What if
can.
it was a commercial enterprise in the second instance? Would they be able to get, would they have to get what the Globe got the year before?
Yes.
So this one request is going to shut down everybody else?
It's not
rest?
shutting, well, I would suggest, Your Honor, it's not shutting anything down. All I'm doing is saying there is a realistic privacy concern raised, not in this case, but in other cases. And there is I think, straightforward solution to it, which is if there is a request that allows for a comparison that would result in a disclosure that's an unwarranted invasion of privacy, there's a different exemption C analysis. As the Superior Court said here, that's not this case because that can't be done. And she recognized that we are all capable of dealing with the next request that raises if it raises a different privacy issue.
so.
May I say one other thing?
This is a one in 2023 or 2027, when somebody comes forward, they're going to remember that the Globe in 2019 got this information, and they're going to say, sorry, nobody else can now get it, because if anybody else gets it, they can compare and they can obtain. I mean, that's a rather peculiar public record circumstance. I don't know of anything comparable.
Well, I think what is peculiar, I would suggest, is we are trying to divine what may happen 10 years from now when, in fact, there may be ways to fashion a request that addresses the privacy concerns that you've just raised. We don't know yet. There is a case before the court that raises no such concern, and there is a possibility raised that in the future there may be a privacy concern. I would suggest there may be ways to address that privacy concern in 2027 or in 2021 even, but it does not. The possibility that a problem will arise in the future is not a substitute for demonstrating that compliance with this request would be an unwarranted invasion of personal privacy.
So the holding you would have us do, apart from if we would choose not to remand, and by the way, do you want us to remand, or do you want us to say they failed to meet their burden and you win?
I prefer the second, but as the brief outlines, Your Honor, we say the threshold test isn't met, so it's over. We recognize that that's the court's decision, and if the court rules otherwise, we think a remand is
Okay,
appropriate.
so, but the holding that you would have is that our opinion, our decision affects only this particular request and would not necessarily govern the evaluation of any future requests for the same information.
In
This is the
substance-
problem that we've been discussing.
In substance, yes, that the court recognizes that a different privacy analysis may be required in future cases if a future request calls for records that would allow for that. It's not the case before us, and it should be addressed at that time, but it's a starkly different privacy analysis.
I just had one more question, maybe one more. If we do what you don't want us to do and we get into the balancing test, and we look at the public interest component of that test, there's an argument as to what we've meant in the last few years and what PETA means in that regard. But if it's limited to the understanding of the operations of government, like in FOIA, do you lose? Because how are you going to know whether or not these records are accurate unless you do what we asked you not to do and compare?
Well, there's, I think,
Because you're looking at to see whether the department has done its job, and I don't know how you're going to know the department's doing its job.
I think, Your Honor, it's very similar to the court's decision in Collector of Lynn. There's I think it's the last footnote in that case. That's the release of tax records. And the court says, oh, you know, there's public interest. You want to know if your neighbor's paying your taxes, and you want to be sure, the last thing they say, that the tax collector is doing its job. And the court drops a footnote and says, by the way, the tax collectors say that they publish annual reports of what they're doing. So everybody, all is fine. There is no public interest in getting the actual tax records. And this court said, no, that's not good enough. And so too here, even at that level, yes, the DPH says, we publish reports. You don't need to know any more than that. We say, well, that's like the Collector of Lynn, because the Collector of Lynn said, don't worry, we publish reports. And this court said, well, no, we can still get the underlying records and compare to the official reports that the agency is issuing.
And as your brief argues, you think that the public interest component of the balancing test is broader than that?
I do submit that it is far too narrow and dangerous an analysis to say that we have to essentially catch a government actor in potential misconduct in order for that balancing test to be satisfied. There are too many records, voting records, registry of deeds, where the information is related to matters of public interest, and that's why we ask that rule not be adopted by the court.
And do you also agree, if we were to remand, that the result of the balancing test could be that you don't get all the information you seek, but only some of it?
Absolutely. Redaction is a very possible remedy here. For example, you mentioned, Chief Justice, you mentioned maiden names. If there was evidence that maiden names posed the problem on a data set and that field can be eliminated, yes. So short answer is yes, I do agree.
Okay, thank you.
Thank you.
Mr. Porter?
Good morning, and may it please the court. William Porter, Assistant Attorney General, here on behalf of the Department of Public Health. I'll begin with the discussion that largely consumed the last portion of Mr. Albano's argument, which is the indisputable fact that if the index is released in response to this case, and then in response, and then in a future request, the then index is released, that information that is prohibited by law from being viewed will be discernible. And as Mr. Albano candidly pointed out, he's conceded that. The Superior Court noted that, and it is clearly in the record in this case, in paragraphs 45 and 46 of the stipulation of facts, which is at paragraph 36 of the record appendix. So what we have is not just a privacy issue, it's clearly an invasion of privacy. But we also have a statutory issue, and I think it's important.
An exemption A.
Exemption A, and I'd like to turn the court's attention, if I might, to Exemption A. It wasn't mentioned by Mr. Albano, but in fact, that was the basis upon which the Supervisor of Public Records held that these indexes are exempt from disclosure. And we know broadly that disclosure of the indexes would be contrary to the scheme in Chapter 46. But we know very specifically that if an index is released today and an index is released in a year, and this is conceded by all parties, comparisons will be permitted. Individuals who've been adopted, their birth parents will be revealed, gender reassignment will be revealed, determinations of non-paternity. So we know that will happen. And that is, has to be, that prospect, a violation of the sections in Chapter 46, 2A, 2B, 13, that prohibit the disclosure of that kind of information. And none of that information is in the index that a person gets on day one, but comparing the indexes does allow the information to be discerned. Mr. Albano's and the Globe's
Could someone
proposal,
could someone do that on the portals, though?
they could not do it on the portals.
Why not?
They,
So if I go to Dorchester and I get into this thing
they-
and I start looking and I can't copy, I write down.
They virtually could not do it on the portals. I suppose if
I guess you-
someone was literally found a needle in a haystack, it might be possible. But the portals are updated nightly to take out restricted information. The portals return only information
But if I have
responsive.
if I have a perverse interest in my neighbor and my neighbor's kids, and I go onto the portal and look, I get all the information, and then a year later, I look at the portal. Am I getting the same? I could find out all the things that the chief discussed, right?
You could, if you.
By process of elimination.
If somebody was that specific and had that intent, we would submit that that would be a misuse of the registry research room, which is.
Well, you don't know that, though.
Excuse me. No, but I'm just saying I'm acknowledging Your Honor's point, that if somebody was that targeted and that malicious and wanted to get restricted information and came annually and checked their neighbor's child's birth, entry in the birth index, I have to concede, I haven't thought of that, but it seems to me that it would be possible. But I think if anything, that suggests a need to tighten the research facility search process, and clearly doesn't suggest that the information should be available, because we know by statute it should not.
Would that situation be able to occur if there were not aggregated data? If there was a
well-
target for, if somebody was targeting a particular person, say you didn't have this index, would there be another way they could check a public record yearly to look for a change?
I suppose conceivably, if someone knew enough information, they could go to the city or town clerk and ask for a certified copy of the child's birth record annually. I suppose it's conceivable they could do that. The point, of course, in this case is that by releasing the index to the public, and once it's released, of course, it isn't just the Globe, it's any requester is entitled to the index if this court determines that it's a public record. Once it's released, this kind of effort could be done, of course, by linking data sets. It could be done on a statewide basis, and many, many, many more privacy invasions would be
Could you address
prospect.
whether or not the finding below about invasion of privacy with respect to identity theft was robust enough for us to rely on it?
I think it is, Your Honor. And I'd like to emphasize that the Commonwealth is not resting entirely on the possibility of identity theft as a basis for why privacy is invaded. I mean, one basis is exactly what we've been talking about, the comparing of the indexes. Another basis is simply the nature of the information. It's sufficiently personal and intimate. But as to the finding on the prospect of identity theft, I think it's as simple as what's released here is clearly personally identifying information. It's a name and a date of birth. And we know from our Commonwealth's identity theft criminal statute that if one obtains personally identifying information and uses it to pose as another person, they've committed a crime. The definition of personally identifying information in that statute, which is Chapter 266, Section 37E, is very broad. It's essentially any information that would identify a person by linking, one or more data points. And we clearly have that here. We have a name and a date of birth. So we're not saying that identity theft would be a certainty or would be inevitable, but we're saying that the Commonwealth would be facilitating the distribution of personally identifying information of the type that those interested in committing identity theft would absolutely want. One's date of birth is a very common identifier. Every time I buy a plane ticket or go to the doctor, I have to give it.
So,
And it's,
and where is the evidentiary record for that?
I'm really asking the court to make one or two connections that are obvious on the face of this record. This record identifies clearly what would be disclosed in the indexes, which if they're disclosed electronically, there'd be millions of entries, and you'd have an individual's name and date of birth. The date of birth linked with the name is personally identifying information under the comptroller's guidance and under the identity theft statute. And so the disclosure would be flooding the public sphere with personally identifying information that would be one piece of the puzzle. We're not saying that identity theft is a certainty, and that's why there are a broad range of privacy concerns that include identity theft. But so the record is absolutely robust enough. It is simply consists of...
What is the record on this?
The record shows what the Globe's request is.
Right.
All birth data since 1953. It shows what the indexes would disclose,
Right.
names and dates of birth. And it shows, we know as a matter of law that the court could conclude that a name and a date of birth is personally identifying information. And when the public...
But you have nothing which you have no affidavit from any identity theft expert giving us any sense of the magnitude of this risk.
That's true. That's true.
And,
There is...
and Mr. Albano points out that the courts don't limit it with regard to it's not part of the information which we restrict from public disclosure, and it's not part of the statute speaking of data privacy. So, I mean, aren't you asking us to, isn't that sort of a stretch for judicial notice?
I don't think so, Your Honor. I think the court could easily conclude that the data breach statute shouldn't govern, because that's the statute that regulates businesses and tells them when they need to create a data security program. That's not as comprehensive, for example, as the comptroller's data privacy guidelines.
I guess my concern, though, in response to Chief's question is, if we're relying on, well, maybe this is enough of an inference, maybe you can take judicial notice. The working premise of government is that people should have as much information as they possibly can have, and we have as much sunshine as we can on government. Maybe this inference is enough, maybe judicial notice here Is that enough for us to say, well, no, this falls within the exemption C, especially every day, information age, the expectation and reality of privacy dissipates.
Absolutely, Your Honor. And we would agree with that assessment that the working premise of the public records law is to shine a light on the operations of government. But we don't have that in this case. What we have is a request for personally identifying information of private citizens, not state employees, not information about what state agency officials are doing in various state programs. We have purely information about private citizens that would be disclosed, information that they have no choice in the submission to the government. It's automatic. And so the cases are clear, and they're clearer on the federal level than in this court. But they're clear that the public interest is at its lowest, the public interest in disclosure, when what is disclosed is purely information about private citizens. I think the Doe case, Doe versus the registrar, stands for that. And certainly on the federal level, we cited a number of cases from the Supreme Court. But back to the question about whether the record is robust enough. What the Globe is doing, of course, is trying to erect a very, very high wall for discerning any privacy implication or privacy right here, so that we don't get to the balancing. We've submitted a variety of reasons that there's a privacy interest, one of which is that there is a risk of identity theft. If this case were to be remanded, the only conceivable basis would be that the evidence would be necessary for the balancing, not for the determination of whether there's a privacy interest, because we already have undisputed evidence of various ways in which privacy will be violated. But it shouldn't be remanded for the balancing either, because the Globe has submitted, and this is what the Superior Court found, essentially one reason that they say disclosure of these millions of data points on private citizens would reveal what the government's doing. They say they want to do a check to see if the registry is correctly entering information about births and marriages. But we've pointed out in our papers how they completely and literally can't do that check, because the indexes, as we've been discussing, do not contain restricted information.
They argue, in fairness, that the second prong of the test is much broader than that, right?
They do argue that, and
So therefore, it's not just that public interest that is at play here, there are others.
they do argue that. It has not been articulated more broadly by this court. This court has very consistently articulated and re-articulated, most recently in the PETA case, that the public interest is in seeing whether public employees are performing their duties in an efficient and law-abiding way. So that's the focus.
Isn't that because that was what was articulated by the side seeking the information?
No, that's directly from the cases, Your Honor.
I understand, but in most circumstances, that's the reason the person seeking the information is claiming is the public interest,
Well-
is to be as a watchdog for government. Here, there is a claim that it's broader, that it may allow us to determine changes in demographics and other types of changes that may be of public interest in terms of analysis of the population, and it's sort of a quasi-census type of analysis. So why is that not a permissible public interest?
Well, it's outside of the public watchdog function. The public watchdog interest is the only interest that's been articulated by this court. And the Supreme Court, in interpreting FOIA, which of course this court has said our statute was based upon, the Supreme Court has been emphatic that the only public interest is the public watchdog interest. So more general
But be a little bit
interests-
careful with that, because if you had important scientific information developed by a public agency, which would help us to solve cancer, is your position that we would say that's not a public interest because it's not helping us to evaluate the Department of Public Health? It's simply going to help us solve cancer?
No, my position is that information like that, that is valuable, that the state has, should be, as a statutory matter, should be made available. And the Department of Public Health has a variety of statutes and a variety of ways in which they can enter into agreements with researchers under appropriate restraints to use valuable data. What we're talking about here is not those kinds of specialized interests, but we're talking about the public records law, in which we know from the Allen case, Allen versus Holyoke Hospital, that the individual interest of the requester isn't what guides the inquiry. It's whether there's a collective public interest in disclosure to see what government is up to.
Okay, so what you're also saying then is that in theory, you could do an MOU with the Globe, if the Globe says we're doing it for scholarly or public purposes, and give it to them pursuant to an MOU, or give it to them to a particular scholar seeking to use that information.
I, as I stand here, don't know the contours of those statutes well enough. My recollection is that one has to be a qualified historian, for example, or particular researchers, and there is flexibility built in to put appropriate restraints on the information so that it could be de-identified, so that it wouldn't disclose individual names, or clearly not ever be made public. All we're talking about here is a question of whether something is a public record, and that's why I think we need to focus on the purposes of the public record statute and not the potential benefits in general of data that might be held by the government. I think that's a different issue. But back to the response to the Globe's particular basis for wanting the documents, they can't do the comparison they say, because the indexes do not show restricted information. One large category of restricted information is out-of-wedlock births. If you look at the most recent report, birth report on the DPH website, that's approximately 30% of births. So the Globe would not get birth information on a large percentage of births, so they couldn't do any valid comparison with the index. It's an incomplete set, and so one couldn't do a meaningful comparison to see if it was complete or not, at least someone reviewing the indexes.
Sorry, are you saying that this data would not include out-of-wedlock births?
The data, the index data does not include, as we've discussed, restricted information. Out-of-wedlock births are restricted information.
So would there be any record of the birth?
Not in the index.
Nothing at all, not even a name, and no other information or a date, or there's no record for it.
My understanding is there will be no entry in the index. If the child, for example, they're unrestricted as a public matter. Certain individuals, such as the child, would have a right to view his or her birth certificate. And so the comparison with the out-of-wedlock, going back to the original point, if one is comparing indexes from 2019 and 2020, the way they see the out-of-wedlock births is by seeing an entry in the 2020 index for a birth certificate where there was an absence under that name and date of birth for any entry, even though the child was born.
You've got me a little confused, because if I know we're not supposed to look to see the intent of the requester, correct, in any of this. So it could be Evil Identity Theft, Inc.,
Right,
right? Or it could be the Globe.
right.
They're all entitled to it. But when we apply the balancing test and we look at the second prong of public interest, you're saying to us that the Globe's not going to know whether or not we're doing our job, neither will Evil Inc., nobody will. So as a matter of law, nobody's going to be able to get this information under your view, correct?
That's correct. What we've said is
So
the,
then why are we here, right? So
Well,
like
I-
if you say we are exempt from this because no one's going to know the inner workings of our government because we're the ones that record births and deaths, and nobody's going to know that, so then you have no right to this information. I don't
Well,
think that flies.
we're not saying that there should never be an audit, for example, of the registry. where a qualified auditor independent auditor could examine this question. We're really just talking about it as a matter of a public records request. And we're talking about it very specifically as a matter of this request, which, because of the restrictions in the index information, since that set is incomplete, it's not a record of all births, one couldn't do what the Globe is saying, look at the index to see if there was a comprehensive number of birth entries. And they really haven't unpacked what they're comparing it against either. They mentioned census data, and they mention it very generally. That was their burden under the cases. Once there's a privacy interest, it is the burden on the requester to show the right and adequate public interest in disclosure. And there was no, if there's any lack of robustness in the record, it's the Globe's failure to submit anything, any expert or detailed evidence on their public interest. Again, one cannot look at the specialized interest of the requester, and that's essentially, I think, what they want.
Okay, so now I missed this, apparently. So if somebody was born out of wedlock and they go to Dorchester, they're not going to find their birth record?
No, what is restricted is public access. If they go,
But so John Smith goes and says, I'm curious to know whether my buddy Billy Thomas was born out of wedlock.
that's not available.
Well, if he looks for Billy Thomas and doesn't find it,
It's an interest.
doesn't that permit the inference that he was born out of wedlock?
Are there other reasons you would
Again-
withhold a birth certificate from the index?
I don't know, actually, if there are other reasons.
So, I mean, if I go to Dorchester and I'm curious to know, I wouldn't, whether you were born out of wedlock, I run your name, would I get it? Or would
Well,
it not be, if you were born out of wedlock, would I not be able to get it?
If that information would be restricted to the public, not to the child, but the public, so it shouldn't be in the index. So,
On the Dorchester Index either.
no, right, the Dorchester Index is what the Globe is requesting. It is not in the Dorchester Index. The,
So I'd have to, and if I were to ask for it, they would say, you're not
you're
Mr.
not
Porter and you don't get it.
entitled, exactly.
Okay,
And-
but does that mean then that if the Globe or somebody gets all of this, and there's a person who is a matter of public interest, and they search and they don't find him or her, can they infer that that person was born out of wedlock because
if-
they're not in the index?
If they know with certainty that the person was born in Massachusetts, and I can't answer with certainty as to all reasons there might not be a birth entry, but that is definitely one reason.
Okay, so I had missed this apparently. So if I am born in Massachusetts and I'm born in wedlock, I'm in there. But if it turns out that the person who I thought my father is not my true father, and there's a paternity change, then I'm still in there, but they would just change the name of the father. Correct?
I'm not sure if I entirely follow Your Honor's question.
So, okay, let's assume that it turns out that my father is not Gus Gantz, but Cary Grant, because I'm way too good-looking to be Gus Gantz's son. And it turns out that, but my parents were married when I was born, and if I were born in Massachusetts, then I would be in there, but
Yes.
they would have changed the birth father to Cary Grant.
Yes.
But if I was born out of wedlock, you wouldn't find me at all.
I believe that's right, Your Honor, and I apologize if I don't have this exactly at the tip of my tongue. I believe when there is an acknowledgement or adjudication of paternity, I believe the record does appear.
So you can be born out of wedlock as long as the mother identifies the father, even if the
Or,
person's not married.
It may be that as long as the father acknowledges paternity or is adjudicated to be the father. I believe that to be the case. If I'm incorrect on that detail, I will follow up and correct that.
We
but
may
I believe
need
that to be
we
the
may
case.
need some clarification
Yes.
from that.
Yes.
As to that, because that's an issue which I don't think is addressed in the briefs, and
Well,
I'm not sure if we understand it entirely.
Right, and I don't think we got into it in that level of detail. But I would submit, Your Honors, that none of these kind of one-off situations where the malicious neighbor goes to search or similar situations should be dispositive of the question of whether these millions of entries can be released as public records electronically.
Are they seeking more than the Dorchester portal at their own desktop?
They are seeking, yes, clearly. At the Dorchester portal, one can enter a search query and get search
Oh,
results.
that's when you have to put in a name, you have to put in AA to be able to get,
Formerly, you had to put in AA. Now that the system has been expanded to include more recent entries and modified somewhat, you actually need to put in a whole name. I submitted a letter to the court on that.
And is there, I mean, how do we understand your argument that these details are not so highly intimate and personal that you can't find them if you go to Dorchester, but they are so highly intimate and personal that collectively they cannot be given to a requesting party?
Well, because they're available when they're given collectively. In Dorchester, one can go and perform a search. You get only the search results. You can't download them, you can't print them, you can't copy them.
it's just more laborious.
Well, it's vastly more laborious. The
That makes
amicus brief
that
said
makes
it
it
would.
more protected.
Yes, and the Supreme Court's term for that under FOIA is it retains practical obscurity. In Dorchester, one cannot scroll through the whole index. It's just not there. You have to do particular searches. You get subsets.
But with appropriate shoe leather, a reporter could do what you want.
It seems nearly impossible to me, because what you're there with a legal pad or a pad of paper, and you're doing,
You take a screenshot?
you cannot take a screenshot.
With your phone?
You cannot bring a camera in. That's on the registry's
Okay.
webpage. No printing, no cameras. And so the reporter would have to be there. So this is the facility open 11 hours a week. And they'd have to do 676 searches that would return up to 4.6 million entries. And that'd be a lot of paper. So the information is, as a practical matter, unavailable. But if it's released electronically, it's not only available for manipulation in terms of computer searches, but aggregation with other identifying information and linking with other
What
identifying
other
information.
steps, if any, would your department have to take to make that data available to the Globe? Would they have to run a program? Would they have to reprogram something? Or would it just be a question of pressing a few keys and sending a list over?
I don't know, as a technical matter, anything more than the following. They would need to extract the data points from their mainframe that correspond to the data points that are reflected in the index, and then provide the information. They're not making an objection based on a technical
Right, no,
problem.
I understand that. I'm just trying to understand whether, in fact, this data collection actually exists as a collection.
It exists on the registry's mainframe.
Right, but
And-
what does the registry do with it, other than piecemeal let people see it?
And that really goes back to our Exemption A argument, which is throughout Chapter 46, you get a very clear sense of what the registry exists for, which is to maintain and preserve official records of vital events. And so that's really what the registry does. And as we pointed out, there is one thing that a member of the public is entitled to get, whether they go to the registry or the town clerk, and that's a certified copy of an individual vital record. And that's produced on special secure paper under the seal of the registrar. And it's usable for what we would expect, to establish one's date of birth, one's citizenship, all kinds of things. That's why the registry exists, is to be an official repository of official vital records. It does not exist to provide a public directory to the Commonwealth. That's nowhere in the statute. And we know that even more particularly from sections 33 and 34, which require now the registry to, which it's done, to create an automated database of vital event information, and that's available expressly under the statute only to town clerks. The following section, Section 34, says there'll be one exception to the issuance of certified copies as a way of releasing vital event data, and that exception is agreements with other public agencies. That's in Section 34. So it's a very tightly controlled.
And so you, in a sense, your department doesn't even have the list, in a way. I mean, it's in the computer, it'd have to be pulled together and
Yes,
extracted.
that's correct.
So there's no studies you're doing, there's no analysis the department's doing of a data set like this that would require them to create the data set?
No, they would have to, as I said, and as I understand in a very amateur sense, pull the data points off their mainframe.
And they don't do it already, for any reason that
They
you
would-
know of?
No, not as a routine matter, definitely not. And if, in case there's any misunderstanding, there is no data of this kind online. So it definitely doesn't exist in that form.
All right, thank you.
Thank you.